feds in the Lil Durk case have responded with a huge motion.
It's about to get worse.
The government's opposition to defendant Banks' motion to sever counts, or in the alternative, to dismiss the third superseding indictment. In my last video, quick summary, Durk's lawyers want to go to trial for the LA murder specifically. And they say Speedy trial right has been violated, so dismiss everything, essentially. This prosecution arises from a coordinated gang murder. At approximately 6 a.m. October 24, 2024, the government executed simultaneous warrants and arrested defendant Banks, 5 co-defendants in and around Chicago. Soon after, defendant Banks began booking international flights in an apparent attempt to flee the United States later that evening. The FBI arrested Banks before he boarded a private flight out of the country, and he and his co-defendants were subsequently charged in the first superseding indictment. So they're still saying he was trying to flee, but I remember his lawyer said something like he already had these flights booked, and there wasn't decoy flights like all the headlines said. I mean, I even said that because that's what it looked like. There was decoy flights for him to not get caught, but it was really just connecting flights across the world to get to Dubai. The FSI outlined the gang-related nature of SR's murder, identified multiple uncharged co-conspirators who conspired to kill Quando Rondo, resulting in SR's death. The government continued to investigate the conspiracy and other criminality linked to defendant Banks and his co-conspirators. The investigation involved robust legal process and the review of voluminous digital records with 59 digital devices and accounts seized. Holy shit. 59. Including 38 following the defendant's arrest. The investigation also revealed the co-conspirators' tradecraft in attempting to evade law enforcement, including witness intimidation, their use of multiple burner phones and messages showing instructions from Enterprise members to delete communications, including defendant Banks telling co-conspirators to delete thread and start a new one. After suspecting an individual provided information to federal law enforcement. Obviously, more charges were returned on June 3rd with the violent crimes in aid of racketeering murder charge. Such superseding charges fall in the heartland of the government's duties and obligations to the public. As many superseding indictments as they want if they find more crimes, is what they're saying. A prosecutor should remain free before trial to exercise the broad discretion entrusted to him to determine the extent of the societal interest in prosecution. That's a crazy statement right there. They're like, we find anything, you're going to get your ass charged with more stuff. Following this, the defense indicated they will require additional time to prepare for trial. Pending before the court is the defendant Banks' motion to sever counts 1 and 6 from the TSI and request that essentially asks this court to cast aside the operative charging document so that defendant Banks can proceed to trial on his choice of counts. The request of severance should be denied. The joinder of defendants and counts in this racketeering murder conspiracy case is proper, just, and warranted. As alleged in the TSI, the murder of SRO was committed by a racketeering enterprise that engaged in, among other crimes, conspiracy, murder, and attempted murder against its rivals. All 6 counts of the TSI expressly incorporated the indictment's
Bro, this is all just like get drawn out and it's just find him guilty already so we could be done with this. Listen, y'all, YouTube and Meta might owe you up to $1,000 if you or your child grew up on social media. If you or your child spent years growing up on social media and experience serious mental health issues, you should hear this. Recently, a jury just ordered Meta and YouTube to pay millions for their role in designing and promoting addictive platforms. They know that their apps can cause anxiety, depression, or body image issues, but they never shared those risks with us. They never made us sign anything that we knew the risk. They just maximized their profits. And the recent historic verdict underscores the consequences of those decisions. But you better not worry. Morgan & Morgan is stepping up to hold these platforms accountable for the harm that they have caused. Click the link in my bio to take a very short questionnaire quiz because you might be entitled to a potential recovery of over $1,000. I ain't gonna lie to you, bro. He already got the other people snitching on him. It's over. It's over. So all y'all trying to save him, the lawyer doing all this bullshit lawyer talk. Oh, drop the charges. Yeah, okay, buddy.
Ain't nobody got time for that.
Okay. Yeah, we demand to drop the charges. You were violating his speedy trial rights. So we demand that you, good luck with that shit, buddy.
Allegations, and for good reason. The enterprise object, manner, and means, and the conspirators' conduct are necessarily intertwined and overlap in this conspiracy case. In his motion, defendant Banks states that if a joint trial on all charges in this TSI proceeds, the government has forced a continuance. Defendant Wilson represented to Judge Aduro prior to the return of the TSI that supplemental charges of the scope described by the government to be returned in the TSI will not permit the August 20 trial to hold, and Mr. Day's pretrial detention is poised to become indefinite. Wilson and Lindsley subsequently told this court in their motion to sever that he does not yet know whether a continuance will be required. The court already indicated it will continue defendant Houston's trial date to afford sufficient time to prepare. So I think the government just pointed out that the lawyers for each defendant have conflicting opinions on whether this causes a continuance.
Right.
Defendant Bank's sole basis to sever the new charges is that a trial on the operative charging document would force a continuance and therefore violate the Sixth Amendment speedy trial rights. That is wrong. There has been no violation of defendant Banks' constitutional speedy trial rights. All defendants, including Banks, requested to continue the trial from late 24 to October 25, and his co-defense then stipulated to continue the trial to its current date. I thought Durk's lawyer said they have not once requested a delay in their document. So someone is fucking tripping here. Who knows, bro? When ordering each request...
Yeah, but aren't they all getting tried on the same... I think if they're all getting tried on the same case, then they can't really, like... They have to take into account all the other lawyers. So if you got 5 people and they all co-defendants, and one of the 5 people, they lawyer says we want to push this back, and you like, okay, cool. I don't need everybody to agree for me to do that. If one person asks, I can say okay or say no.
To continue, the court made findings of excludable time under the Speedy Trial Act, including that the case was complex and unusual. The defendants were joined for trial and no severance has been granted. And the court's broad power to delay trial when the ends of justice are served by the continuance. If the court were to further continue the trial, the court would undoubtedly evaluate the merits of the request and make similar appropriate findings that comply with the Speedy Trial Act and the Constitution. The remedy for defendant Banks' request is straightforward: a continuance for the trial. For those reasons, and for those set forth below, the court should deny defendant Banks' motion to sever. All right, fellas, let's be honest. Buying jewelry can't... Through Cough Boys. Go cop it for summertime. Appreciate you, boys. Back to the video. Just hours after the arrest of his defendants, Banks started booking multiple flights out of the United States. Is that proven? I was unaware that he booked the flights after his homeboys got arrested.
Yeah, I knew that.
Thought one of his lawyers said those flights were booked for a while. Apparently, he was planning to move to Dubai at some point, so he already had this whole plan. It wasn't because his boys got arrested.
Oh.
So someone's lying again. All right, here.
So he just happened to be moving to Dubai. He just happened to have all these flights. And he just happened to have them right after his friends got arrested. You know, didn't they catch him at the airport? Right? Let me see something. Hold on. Where was Lil Durk arrested? In Florida. He was arrested in the vicinity of the Miami airport. So he just so happened to be about to get on the plane while the feds looking for him and arrested his other homeboys. Just coincidence, right?
Here's December 31st, 2024. Banks, Grant, Wilson, Jones, and Lindsay requested a continuance and signed a stipulation to continue trial to October 14th. Durk filed a motion to dismiss the case. Government filed the second superseding indictment May 1st, 2025. Wilson, Lindsay, and Houston stipulated to continue the trial to January 20th, 2026. January 5th, defendant Wilson, Lindsay, and Houston requested continuance and entered stipulation to continue the trial to May 4th. The court ordered trial continued to April 21st at some point in January. Defendant Wilson, Lindsay, and Houston stipulated to continue trial to August now. So his other co-defendants seem to be pushing the trial back because they want more time.
Right.
Is what I'm getting from this. Court ordered trial continued.
Because you think about it, bro, the other co-defendants lawyers probably want more time to be like, shit, let's try to make my client look innocent and make somebody else's client look guilty. I don't care. As long as my client walks, I get the W. That's how a lawyer gonna look at it. So shit, I'm not surprised that they asking for it to get pushed back.
August 20th and made excludable
but
time.
Of course, Lil Durk lawyers wanted to get pushed back because Lil Durk lawyers is like, shit, the more evidence they find, the more we're fucked. So let's hurry up and do this. Come on.
For the trial. April 2026, Anthony Montgomery Wilson, or Mike City AJ, pled guilty in Chicago to use of a firearm during and in relation to a crime of violence for murdering SM, a consideration for the promise and agreement to pay sum of money for individual C. Wilson further admitted under oath that after murdering SR, he collected money that had been offered as consideration for SM's murder. SM is the murderer Stefan Mack, by the way, if you guys don't remember, just to clarify. The two guys that were involved in that killing, I think one took a plea deal recently. I thought they were texting at some point asking if OTF has paid them. Preston Powell took a plea deal. Stefan Mack, among other things, defendant Powell admitted there was cash bounty for SM's murder and that he participated in conspiracy with Montgomery Wilson to murder SM and collect payment. Defendant Wilson and Lindsay filed a renewed motion to sever. Defendant Houston filed a motion to sever or continue trial. Defendant Banks filed a current motion to sever the case into 2 trials, an August 26 trial for the 2 counts and the other new charges separately. After the arrest, they continued to investigate these boys. Government identified numerous text messages between enterprise members discussing racketeering activity, including communications about identifying suspected informants. For example, on August 23, Banks sent a group text message to co-conspirators and enterprise members, including defendant Wilson, stating that a suspected government informant shooter during the 2022 LA murder of SR was just ready to snitch blood, clear as day. He gonna tell soon. Defendant Banks then reassured the group chat, sending a follow-up text stating, as long as we don't break, they can tell him whatever. So what I'm getting from this is Durk thought one of the shooters in the LA murder was going to snitch. So they got search warrants in 2025 and found 2 contraband devices that defendant Banks used to have unmonitored communications while incarcerated, and iCloud accounts associated with defendant Banks' contraband devices. To date, the government has produced approximately 4.5 terabytes of digital evidence from approximately 59 digital devices and accounts. What is on these devices, man? Self-snitching. They took significant steps to prevent law enforcement detection and conceal evidence. In July 23, group text message thread between defendant Banks, co-conspirator 6, and other Banks Gang Enterprises members. Defendant Banks instructs the group to delete the text thread and start a new one. After co-conspirator 6 sends a voice message record to the group chat suggesting police had recently arrested someone and were asking about defendant Banks, co-conspirator 6, and Banks Gang Enterprise members. Co-conspirator 6, this is Zoo, right? Then sends instructions to the group on how to further conceal evidence by deleting text messages from iCloud storage. Oh my god, these boys were panicking, like, delete this shit from your iCloud too. Additionally, co-conspirator...
But here's the thing. So if you know that you have to delete something from iCloud, how fucking stupid do you have to be to even talk about the murder on the text message in the first place? There will be nothing to delete if y'all claiming y'all so fucking stupid. Y'all claiming y'all innocent. So what is there to delete? If you sit here talking about a murder that y'all know y'all did. So if y'all smart enough to delete it from iCloud, you should be smart enough to not talk about the fucking murder in text messages in the first place. You should be smart enough to know that the feds can find messages that you deleted. You should be smart enough to know that. I don't understand.
Shooters often use multiple burner phones and will dispose of the phones after violence to prevent law enforcement from obtaining relevant information, as defendant Banks did after SR's murder. So yeah, remember they got proof that someone went to a Verizon store a day or two after the murder in LA. After murder of Stephon Mack in Chicago, defendants Montgomery Wilson and Powell discussed collecting the bounty for killing him. Specifically, defendant Powell was sent a text message from Montgomery Wilson saying, "What's up with OTF? What do you mean they not paying?" In response, Montgomery Wilson wrote, "We waiting for Banks to come up here on the 17th. Now the attempted murder of AW in Atlanta. This is involving King Von and Durk when they were arrested in 2019. And Fonnie Willis dropped the charges for whatever reason against Durk. Like, they didn't even give a reason why. They were like, we're just going to drop the charges.
They're going to drop the charges because the feds called them. FBI, open up! I think the feds called them and said, don't worry about it. Just drop the charges for us. Don't worry. We got them. And then a few months later, they came and got his dumb ass.
Some people think it was the Fed telling him to drop it, but I don't think it was that. Defense sole basis for the severance is because it would violate his Sixth Amendment right to a speedy trial. Analysis factually and legally unsupported. Ninth Circuit law compels a joint trial on all properly joined charges in the TSI, which will ensure a streamlined and orderly presentation of evidence, conserve judicial resources, and minimize the risk to witnesses. Holding 2 trials, including one that pretends the enterprise allegations do not exist, would deprive the jury of a complete understanding of the alleged gang enterprise, including how and why the LA murder occurred. The government's like, hell nah, you ain't having 2 trials, Durk. Defendant Banks should be tried on all charges contained in the TSI. Severance is not warranted unless a joint trial would violate defendant's substantive rights. Here, joint trial on all counts in the TSI permits judicial economy and ensures the jury has before it the evidence necessary to evaluate this gang murder. Even if the enterprise allegations were not incorporated into the murder for hire counts, the government's evidence, including defense admissions and anticipated co-conspirator testimony, defendant's admissions. These cases with all these people, someone will snitch, bro.
Hell yeah.
There's always going to be
absolutely.
Snitches. A joint trial here also serves another compelling purpose and minimizing the risk to witnesses who have agreed to cooperate against defendant Banks and his co-defendants. There have already been multiple threats to cooperating witnesses and their family members in this case, as well as outside spectators who have shown their willingness to violate court rules and publicly intimidate suspected witnesses, requiring these witnesses to repeat their testimony in multiple trials, including duplicating the extra precautionary security measures court staff and the U.S. Marshal Service will undoubtedly have to take attendant to these witnesses' travel and testimony, strongly militates in favor of a joint trial. So they're saying, we got to protect witnesses that are going to snitch. We can't have 2 trials just in case, in between these
Extra
trials,
shit
something
happened.
happens to these witnesses.
Yeah.
Defendant Banks asked the court to set aside the facts that compel a joint trial and instead sever the violent crimes and aid of racketeering counts based on hypothetical future violation of his constitutional right to a speedy trial. That argument lacks merit. To start, it is unclear what precise delay Defendant Banks' search would be unconstitutional. Defendant Banks requested a continuance between November 24 and October 25, 11 months, and the time period between October 25 and the current trial date was requested by his co-defendants with whom he is joint for trial and no severance was granted. Defendant Banks cannot plausibly contend that the first 11 months that he requested was unconstitutional, nor does he provide any case law of that. At its core, Defendant Banks' motion hinges on its conclusion that any continuance would violate his speedy rights, because the delay would purportedly base the government on sandbaggery or gamemanship. But this is simply not the case. The government's decision to supersede was a good faith exercise of prosecutorial discretion that followed material developments in the government's investigation. Because people started snitching in that murder of Stefan Mack.
Exactly.
After the government arrested and charged the defense,
so it's over with. Can we just come to that conclusion at this point? It's over. It's at this point he's just delaying his fate. I don't understand how you could sit in a federal prison knowing damn well you did this shit. Like, bro, I would have just took a plea deal. I'm not telling my lawyer to do all this. Hey, can you get a plea deal? Can you try to give me 30 years at this point, nigga? If they get you 30 years, you need to take 30 years, because if you go to trial and you blow this trial, which you're probably 9 times out of 10 going to blow the trial, you're not coming home. I promise to God, Lil Durk is not getting out of jail if he blows trial. He better take a plea deal. Even if they get your ass 40 years, you better sit your motherfucking ass down. Come home when you're 70, nigga. I don't know what you want me. Ain't nobody tell you to go kill them niggas. That's your dumb ass. You could have called the police like a regular old good rich citizen, and you wouldn't be in jail. They would. Dumbass. You wanted to be tough though, so now your kids got to grow up without a dad. Because you wanted to be tough. If that was worth it to you, then cool.
Included by searching 38 digital devices. As the investigation continued, the government sought and obtained additional search warrants. Oh, here's the big part. Remember, Durk's lawyers said that they took the Chicago incident off the table, and they said that in court, and then suddenly they added it to the new indictment, like kind of blindsiding the defense with a murder that they said they weren't going to involve in this. Additionally, defense argument that the government took the Chicago incident off the table when it withdrew its motion to admit it under Rule 404B. In April and May of 2026, Mike City AJ pled guilty and admitted under oath that they murdered SM to collect a bounty payment from Individual C. Individual C is Durk, I think? Or is that DD? I can't remember who Individual C was. I figured this out a few videos ago. God damn it. Evidence at trial will establish the murder was committed on behalf of Banks Gang Enterprise, including text message described above where Chicago defendants discussed collecting the bounty payment from defendant Banks and OTF, photos and videos seized from the Chicago defendants' digital devices, and jailhouse confession by one of the Chicago defendants. Oh, always talking to people in jail. Self-snitching. Someone going to tell the police this shit because they want to try to get a better case.
Time better,
the government's decision to bring additional charges in the TSI was good faith, exercise of prosecutorial discretion, including witness safety, compel a joint trial in this case, blah, blah, blah. And they cite a shit ton of cases that none of this delay is violating his constitutional rights to a speedy trial. Defendant Banks does not credibly point to any specific damage to his defense stemming from the delay in this trial. Oh, we got some text here from Zoo. Lil dude, little brother, police, question mark. I think this is Durk, because this is a perspective from Zoo's phone, I think. 30 said ATF. I don't know who 30 is. Who's 30? Durk says delete thread and start a new one. Zoo says when y'all delete, click on the edit sign and clear all deleted too. It's in the new update, so it won't stay in the iCloud. These boys staying up to...
God, come on, bro. Like, what are we talking about? Finish it. Just go ahead and get him up out of here.
Call the popo, ho.
Like, come on, gang. Come on, gang. Y'all can't be this fucking stupid. It's impossible to be a grown man and be this dumb. You didn't even have enough, like, y'all didn't even have enough, like, sense to be like, let's not talk about, hey, pull up, I'm trying to talk to you about something, bro. Pull up to the spot real quick. Leave your phone in the car, go in there and talk. Y'all ain't never seen Power? That's what they do on Power. Y'all ain't that, that's fucking stupid? I'm talking about, you gonna text the motherfucker and tell him to delete the thread. Like, boy,
yeah,
y'all ass
30.
dumb, gang.
Durk says delete thread and start a new one. Zoo says when y'all delete, click on the edit sign and clear all deleted too. It's in the new.
And he screenshot it and sent, look at this shit. I want y'all to see, okay? So when you think that you're deleting something, this is what the feds see from their side. They see what you said. They see the screenshot that you took. They got the file name. They got the iCloud reference. They got the library attachment. All this shit. They got it. What time it got read. What time it got delivered. What time the video message might have got played. The time y'all look. This is 7/3. You'll see this 7/3 at 5 o'clock in the morning.
Update so it won't stay in the iCloud. These boys staying up to date on iCloud updates to delete shit. Yeah, I've been saying for a while it doesn't look good for Durk, but he has some really good lawyers. Who knows whether they can do a trial, but he's going to trial with all his co-defendants. There's going to be snitching. He's cooked. You know what I'm saying? Like, it's not looking good. Hit subscribe.
Thank you. I just say he could, because y'all be trying to. A lot of these niggas be trying to make it seem like, oh, he got a chance. No, he don't. They snitching on him. They got messages. They got phone calls. They got. Come on, gang. He just in that bitch delusional. Yeah, don't worry, we gonna beat it. This is the same nigga that said Rondo was coming home. He said Rondo was coming home 5 years straight. Motherfucker Rondo sitting there doing 50 years, man. Come on, man. Come on.